This is a short video of what's involved in a High Court personal injury claim. People ask, what actually is the process? Unless you've been involved in litigation before, the entire High Court compensation process can be a mystery. There are various steps which are carried out. Firstly, if your case has been moved on by the injury board and you've issued your proceedings, the first thing is to have a summons issued. This is issued through the High Court office. It contains details of the other side who injured you and also the details of what you are claiming and what your outlays have been, such as your medical expenses, your loss of earnings, etc. This is usually picked up by an insurance company for the unsuccessful party, and they have their own panel of solicitors who will enter what is known as an appearance. What follows then is a series of inquiries as to what detail is involved in the claim, and they usually serve what is called a notice for particulars. This is a document with anything from 20 to 40 questions asking for detail in relation to why do we say their insured was liable, what do we say are the outlays you have incurred, and in relation to the injuries, what do you say your medical condition is going to be into the future. Once these replies are sent back to the defendant's solicitors, they are under an obligation then to enter a defence. A defence is basically a document which denies that the defendant was liable. It is always confusing to a layperson as to why everything is denied, even that they're insured were even there on the day of the accident, when quite clearly the accident happened. Remember, in legal terms, anything that's not denied is deemed to be accepted. But this is very often hard to understand for a layperson. What happens now in more recent years is a demand for discovery of all your medical history. This is simply that each side is asked to disclose what they have on their file prior to the issue of proceedings. In an accident case, for example, in a factory, it may well be the accident report form. How was it filled out and what were the details included in it? In car accident cases, it usually means production of your medical notes. In commercial law cases, it is very common and involves a lot of paperwork. Very often each side wants to see the files which were in existence before a dispute broke out. Discovery can be detailed and can involve a lot of documents, so it can either be requested on a voluntary basis or it might be necessary to seek a court order to actually produce the discovery. You're generally asked then to sign a sworn statement known as an affidavit to indicate that all the documentation you have, and if there's some document you don't wish to produce, you can claim privilege over it. If discovery is completed, then the next stage is for the plaintiff to serve a notice of trial. This in the High Court means that it's set down for trial in a list of cases either in Dublin or various country venues during the year. While there are a lot of cases set down at any given time, it is possible, if the case is ready to go ahead, to simply apply to the court to move the case into a list for hearing on a particular day. With that, the witnesses which are necessary, such as doctors or engineers, if there's a dispute how the accident happened, are all to be summoned to the court. This is the solicitor's job for the plaintiff to ensure that all persons are available on the day of the court. What happens is the case moves to the control of a senior counsel barrister who prepares a document known as an advice on proofs. This is simply a list of instructions for what to do to get the case ready. It is the solicitor's job to comply with this list of requirements so that all the necessary witnesses are there. In practical terms, very often the outlays on a case, such as travel, car or medical expenses, can all be agreed in advance without the need to bring a witness along for each claim. Very often as well, the medical evidence on the reports can be handed into court without the need to bring the doctors along to court. Doctors are busy and they don't give great priority to attending a court and waiting around when they could be involved in more serious business in their normal work. Most courts will now agree to enter the medical evidence by handing up the medical reports to the judge. Sometimes the cases are settled at the door of the court. Sometimes it's necessary to start a case, and during the case may settle. Sometimes cases go on to a full conclusion when a judge must give a decision on the case. One thing to be aware of is that if a case is released by the injury board, or if the plaintiff does not accept an amount offered by the injury board, it is necessary that the High Court or Circuit Court amount ultimately awarded is more than the actual amount offered by the injury board. If not, there is a liability for costs for the plaintiff who did not, what they call, beat the lodgment. That is a phrase used simply to say if you are not awarded more than the court, then you are offered in the injury board, then you're liable to pay the insurance company costs and indeed your own costs of the case, which is not a very pleasant experience, as you can imagine. As always, if you wish to have clarification of any of the matters in relation to your present High Court case or one which you may be taking in the near future, please contact us now on our number or by email